Chapter 8. Regulation of Securities Market Professionals. Section 28. Registration of brokers, dealers, salesmen, and associated persons. 28.1. No person shall engage in the business of buying or selling securities in the Philippines as a broker or dealer, or act as a salesman, or an associated person of any broker or dealer unless registered as such with the Commission. 28.2. No registered broker or dealer shall employ any salesman or any associated person, and no issuer shall employ any salesman, who is not registered as such with the Commission. 28.3. The Commission, by rule or order, may conditionally or unconditionally exempt from subsection 28.1 and 28.2 any broker, dealer, salesman, associated person of any broker or dealer, or any class of the foregoing, as it deems consistent with the public interest and the protection of investors. 28.4. The Commission shall promulgate rules and regulation prescribing the qualifications for registration of each category of applicant, which shall, among other things, require as a condition for registration that a. If a natural person, the applicant satisfactorily pass a written examination as to his proficiency and knowledge in the area of activity for which registration is sought. b. In the case of a broker or dealer, the applicant satisfy a minimum net capital as prescribed by the Commission, and provide a bond or other security as the Commission may prescribe to secure compliance with the provisions of this code, and c. If located outside of the Philippines, the applicant files a written consent to service of process upon the Commission pursuant to Section 65 hereof. 28.5. A broker or dealer may apply for registration by filing with the Commission a written application in such forms and containing such information and documents concerning such broker or dealer as the Commission by rule shall prescribe. 28.6. Registration of a salesman or of an associated person of a registered broker or dealer may be made upon written application filed with the Commission by such salesman or associated person. The application shall be separately signed and certified by the registered broker or dealer to which such salesman or associated person is to become affiliated, or by the issuer in the case of a salesman employed, appointed, or authorized solely by such issuer. The application shall be in such form and contain such information and documents concerning the salesman or associated person as the Commission by rule shall prescribe. For purposes of this section, a salesman shall not include any employee of an issuer whose compensation is not determined directly or indirectly on sales of securities if the issuer. 28.7. Applications filed pursuant to subsections 28.5 and 28.6 shall be accompanied by a registration fee in such reasonable amount prescribed by the Commission. 28.8. Within 30 days after the filing of any application under this section, the Commission shall by order, a. grant registrations if it determines that the requirements of this section and the qualifications for registration set forth in its rules and regulations have been satisfied, or b. deny said registration. 28.9. The names and addresses of all persons approved for the registration as brokers, dealers, associated persons, or salesmen and all orders of the Commission with respect thereto shall be recorded in a register of securities market professionals kept in the office of the Commission, which shall be open to public inspection. 28.10. Every person registered pursuant to this section shall file with the Commission, in such form as the Commission shall prescribe, information necessary to keep the application for registration current and accurate, including in the case of a broker or dealer changes in salesmen, associated persons, and owners thereof. 28.11. Every person registered pursuant to this selection shall pay to the Commission an annual fee at such time and in such reasonable amount as the Commission shall prescribe. Upon notice by the Commission that such annual fee has not been paid as required, the registration of such person shall be suspended until payment has been made. 28.12. The registration of a salesman or associated person shall be automatically terminated upon the cessation of his affiliation with said registered broker or dealer or with an issuer in the case of a salesman employed, appointed, or authorized by such issuer. Promptly following any such cessation of affiliation, the registered broker or dealer, issuer as the case may be, shall file with the Commission a notice of separation of such salesman or associated person. Section 29. Revocation, refusal, or suspension of registration of brokers, dealers, salesmen and associated persons. 29.1. Registration under Section 28 of this Code may be refused, or any registration granted thereunder may be revoked, suspended, or limitations placed thereon, by the Commission if, after due notice and hearing, the Commission determines the application or registrant a. has willfully violated any provision of this Code, any rule, regulation, or order made hereunder, or any other law administered by the Commission, or in the case of a registered broker, dealer, or associated persons has failed to supervise, with a view to preventing such violation, another person who commits such violation. b. has willfully made or caused to be made a materially false or misleading statement in any application for registration or report filed with the Commission or a self-regulatory organization, or has willfully omitted to state any material fact that is required to be stated therein. c. has failed to satisfy the qualifications or requirements for registration prescribed under Section 28 and the rules and regulations of the Commission promulgated thereunder. d. has been convicted, by a competent judicial or administrative body of an offense involving moral turpitude, fraud, embezzlement, counterfeiting, theft, estafa, misappropriation, forgery, bribery, false oath, or perjury, or of a violation of securities, commodities, banking, real estate, or insurance laws. e. is enjoined or restrained by a competent judicial or administrative body from engaging in securities, commodities, banking, real estate, or insurance activities or from willfully violating laws governing such activities. f. is subject to an order of a competent judicial or administrative body refusing, revoking, or suspending any registration, licensed or other permit under this Code, the rules and regulations promulgated thereunder, any other law administered by the Commission. g. is subject to an order of a self-regulatory organization suspending or expelling him from membership or participating therein or from association with a member or participant thereof. h. has been found by a competent judicial or administrative body to have willfully violated any provisions of securities, commodities, banking, real estate, or insurance laws, or has willfully aided, abetted, counseled, commanded, induced, or procured such violation, or I. has been judicially declared insolvent. For purposes of this subsection, the term competent judicial or administrative body shall include a foreign court of competent jurisdiction and a foreign financial regulator. 29.2. a. in case of charges against a salesman or associated person, notice thereof shall also be given the broker, dealer, or issuer employing such salesman or associated person. b. pending the hearing, the Commission shall have the power to order the suspensions of such brokers, dealers, associated persons or salesmen's registration, provided that such order shall state the cause for such suspension. Until the entry of a final order, the suspension of such registration, though binding upon the persons notified thereof, shall be deemed confidential, and shall not be published, unless it shall appear that the order of suspension has been violated after notice. 29.3. The orders of the Commission refusing, revoking, suspending, or placing limitations on a registration as herein above provided, together with its findings, shall be entered in the Register of Securities Market Professionals. The suspension or revocation of the registration of a dealer or broker shall also automatically suspend the registration of all salesmen and associated persons affiliated with such broker or dealer. The order of the Commission refusing, revoking, suspending, or placing limitations on a registration as herein above provided, together with its findings, shall be entered in the Register of Securities Market Professionals. The suspension or revocation of the registration of a dealer or broker shall also automatically suspend the registration of a dealer or broker shall also automatically suspend the registration of all salesmen and associated persons affiliated with such broker or dealer. 29.4. it shall be sufficient cause for refusal, revocation, or suspension of a broker's or dealer's registrations, if any associated person thereof or any juridical entity controlled by such associated person has committed any act or omission or is subject to any disability enumerated in paragraphs A through I of subsection 29. I hereof. Section 30. Transactions and responsibility of brokers and dealers. 30.1 No brokers or dealer shall deal in or otherwise buy or sell, for its own account or for the account of customers, securities listed on an exchange issued by any corporation where any stockholders, director, associated person, or salesman, or authorized clerk of said broker or dealer and all the relatives of the foregoing within the fourth civil degree of consanguinity or affinity, is at the same time holding office in said issuer corporation as a director, president, vice president, manager, treasurer, controller, secretary or any office trust and responsibility, or is a controlling of the issuer. 30.2. No broker or dealer shall effect any transaction in securities or induce or attempt to induce the purchase or sale of any security except in compliance with such rules and regulations as the Commission shall prescribe to ensure fair and honest dealings in securities and provide financial safeguards and other standards for the operations of brokers and dealers, including the establishments of minimum net capital requirements, the acceptance of custody and use of securities of customers, and the carrying and use of deposits and credit balances of customers. Section 31. Development of securities market professionals. The Commission in joint undertaking with self-regulatory organizations, and associations of finance professionals as well as private educational and research institutes shall undertake or facilitate/organize continuing training, conferences/seminars, updating programs, research and developments as well as technology transfer at the latest and advanced trends in issuance and trading of securities, derivatives, commodity trades and other financial instruments, as well as securities markets of other countries. Chapter 9. Exchanges and other securities trading markets. Section 32. Prohibition on use of unregistered exchange, regulation of over-the-counter markets. 32.1. No broker, dealer, salesman, associated person of a broker or dealer, or exchange, directly or indirectly shall make use of any facility of an exchange in the Philippines to effect any transaction in a security, or to report such transaction, unless such exchange is registered as such under Section 33 of this Code. 32.2. A. No broker, dealer, salesman, or associated person of a broker or dealer, singly or in concert with any other person, shall make, create or operate, or enable another to make, create, or operate, any trading market, otherwise than on a registered exchange, for the buying and selling of any security, except in accordance with rules and regulations the Commission may prescribe. B. The Commission may promulgate rules and regulations governing transactions by brokers, dealers, salesmen, or associated persons of a broker or dealer, over any facilities of such trading market and may require such market to be administered by a self-regulatory organization determined by the Commission as capable of ensuring the protection of investors comparable to that provided in the case of a registered exchange. Such self-regulatory organization must provide a centralized marketplace for trading and must satisfy requirements comparable to those prescribed for registration of exchanges in Section 33 of this Code. Section 33. Registration of exchanges. 33.1. Any exchange may be registered as such with the Commission under the terms and conditions hereinafter provided in this section and Section 40 hereof, by filing an application for registration in such form and containing such information and supporting documents as the Commission by rule shall prescribe, including the following. A. An undertaking to comply and enforce by its members with the provisions of this Code, its implementing rules and regulations and the rules of the exchange. B. The organizational charts of the exchange, rules of procedure, and a list of its officers and members. C. Copies of the rules of the exchange, and D. an undertaking that in the event a member firm becomes insolvent or when the exchange shall have found that the financial condition of its member firm has so deteriorated that it cannot readily meet the demands of its customers for the delivery of securities and/or payment of sales proceeds, the exchange shall, upon order of the Commission, take over the operation of the insolvent member firm and immediately proceed to settle the member firm's liabilities to its customers. 33.2. Registrations of an exchange shall be granted upon compliance with the following provisions. A. That the applicant is organized as a stock corporation, provided that any registered exchange existing prior to the effectivity of this code shall within 1 year reorganize as a stock corporation pursuant to a demutualization plan approved by the Commission. B. That the applicant is engaged solely in the business of operating an exchange, provided, however, that the Commission may adopt rules, regulations, or issue an order, upon application, exempting an exchange organized as a stock corporation and owned and controlled by another juridical person from the restriction. C. Where the exchange is organized as a stock corporation, that no person may beneficially own or control, directly or indirectly, more than 5% of the voting rights of the exchange, and no industry or business group may beneficially own or control, directly or indirectly, more than 20% of the voting rights of the exchange, provided, however, that the Commission may adopt rules, regulations, or issue an order, upon application from this prohibition where it finds that such ownership or control will not negatively impact on the exchange's ability to effectively operate in the public interest. D. The expulsion, suspension, or disciplining of a member and persons associated with a member for conduct or proceeding inconsistent with just and equitable principles of fair trade, and for violations of provisions of this code, or any other act administered by the Commission, the rules, regulations, and orders thereunder, or the rules of the exchange. E. A fair procedure for the disciplining of members and persons associated with members, the denial of membership to any person seeking to be a member, the barring of any person from association with a member, and the prohibition or limitation of any person from association with member, and the prohibition or limitation of any person from access to services offered by the exchange. F. That the brokers in the board of the exchange shall comprise of not more than 49% of such board and shall proportionately represent the exchange membership in terms of volume/value or trade and paid-up capital, and that any natural person associated with a juridical entity that is a member for this purpose, provide that any registered exchange existing prior to the effectivity of this code shall immediately comply with this requirement. G. For the board of the exchange to include in its composition, 1. The president of the exchange, and 2. No less than 51% of the remaining members of the board to be comprised of 3. Independent directors and persons who represent the interests of issuers, investors, and other market participants, who are not associated with any broker or dealer or member of the exchange for a period of 2 years prior to his/her appointment. No officer or employee of a member, its subsidiaries, or affiliates or related interests shall become an independent director, provided, however, that the Commission may by rule, regulation, or order upon application, permit the exchange organized as a stock corporation to use a different governance structure, provided, further, that the Commission is satisfied that the exchange is acting in the public interest and is able to effectively operate as a self-regulatory organization under this code. Provided, finally, that any registered exchange existing prior to the effectivity of this code shall immediately comply with this requirement. H. The president and other management of the exchange to consist only of persons who are not members and are not associated in any capacity, directly or indirectly with any broker or dealer or member or listed company of the exchange, provided that the exchange may only appoint, and a person may only serve, as an officer of the exchange if such person has not been a member or affiliated with any broker, dealer, or member of the exchange for a period of at least 2 years prior to such appointment. I. The transparency of transactions on the exchange. J. the equitable allocation of reasonable dues, fees, and other charges among members and issuers and other persons using any facility or system which the exchange operates or controls. K. Prevention of fraudulent and manipulative acts and practices, promotion of just and equitable principles of trade, and, in general, protection of investors and the public interest, and L. The transparent, prompt, and accurate clearance and settlement of transactions effected on the exchange. 33.3. If the Commission finds that the applicant exchange is capable of complying and enforcing compliance by its members, and persons associated with such members, with the provisions of this code, and the rules of the exchange, and that the rules of exchange are fair, just and adequate, the Commission shall cause such exchange to be registered. If, after notice due and hearing, the Commission finds otherwise, the application shall be denied. 33.4. Within 90 days after the filing of the application, the Commission may issue an order either granting or denying registration as an exchange, unless the exchange applying for registration shall withdraw its application or shall consent to the Commission's deferring action on its application for a stated longer period after the date of filing. The filing with the Commission of an application for registration by an exchange shall be deemed to have taken place upon the receipt thereof. Amendments to an application may be made upon such terms as the Commission may prescribe. 33.5. Upon the registration of an exchange, it shall pay a fee in such amount and within such period as the Commission may fix. 33.6. Upon appropriate application in accordance with the rules and regulations of the Commission and upon such terms as the Commission may deem necessary for the protection of investors, an exchange may withdraw its registration or suspend its operations or resume the same. Section 34. Segregation and limitation of functions of members, broker, and dealers. 34.1. It shall be unlawful for any member broker of an exchange to effect any transaction on such exchange for its own account, the account of an associated person, or an account with the respect to which it or an associated person thereof exercises the investment discretion, provided, however, that this section shall not make unlawful a. Any transaction by a member broker acting in the capacity of a market maker. b. Any transaction reasonably necessary to carry on an odd lot transactions. c. Any transaction to offset a transaction made in error, and d. Any other transaction of a similar nature as may be defined by the Commission. 34.2. In all instances where the member broker effects a transaction on an exchange for its own account or the account of an associated person or an account with the respect to which it exercises investment discretion, it shall disclose to such customer at or before the completion of the transaction it is acting for its own account, provided, further, that this fact shall be reflected in the order ticket and the confirmation slip. 34.3. Any member broker who violates the provisions of this section shall be subject to the administrative sanctions provided in Section 54 of this Code. Section 35. Additional fees of exchanges. In addition to the registration fee prescribed in Section 33 of this Code, every exchange shall pay to the Commission, on a semestral basis on or before the 10th day of the end of every semester of the calendar year, a fee in such an amount as the Commission shall prescribe, but not more than 1/100th of 1%, of the aggregate amount of the sales of securities transacted on such exchange during the preceding calendar year for the privilege of doing business during the preceding calendar year or any part thereof. Section 36. Powers with respect to exchanges and other trading market. 36.1. The Commission is authorized, if in its opinion such action is necessary or appropriate for the protection of investors and the public interest so requires, summarily to suspend trading in any listed security on any exchange or other trading market for a period not exceeding 30 days but not exceeding 90 days, provided, however, that the Commission promptly following the issuance of the order of suspension, shall notify the affected issuer of the reasons for such suspension and provide such issuer with an opportunity for hearing to determine whether the suspension should be lifted. 36.2. Wherever two or more exchanges or other trading markets exist, the Commission may require and enforce uniformity of trading regulations in and/or between or among said exchanges or other trading markets. 36.3. In addition to the existing Philippine Stock Exchange, the Commission shall have the authority to determine the number, size, and location of stock exchanges, other trading markets and commodity exchanges and other similar organizations in the light of national or regional requirements for such activities with a view to promote, enhance, protect, conserve, or rationalize investment. 36.4. The Commission, having due regard to the public interest, the protection of investors, the safeguarding of securities and funds, and maintenance of fair competition among brokers, dealers, clearing agencies, and transfer agents, shall promulgate rules and regulations for the prompt and accurate clearance and settlement of securities transactions. 36.5. A. The Commission may establish or facilitate the establishment of trust funds which shall be contributed by exchanges, brokers, dealers, underwriters, transfer agents, salesmen, and other persons transacting in securities, as the Commission may require, for the purpose of compensating investors for the extraordinary losses or damage they may suffer due to business failure or fraud or mismanagement of the persons with whom they transact, under such rules and regulations as the Commission may from time to time prescribe or approve in the public interest. B. The Commission may, having due regard to the public interest or the protection of investors, regulate, supervise, examine, suspend or otherwise discontinue such and other similar funds under such rules and regulations which the Commission may promulgate, and which may include taking custody and management of the fund itself as well as investments in and disbursements from the funds under such forms of control and supervision by the Commission as it may from time to time require. The authority granted to the Commission under this subsection shall also apply to all funds established for the protection of investors, whether established by the Commission or otherwise. Section 37. Registration of innovative and other trading markets. The Commission, having due regard for national economic development, shall encourage competitiveness in the market by promulgating within 6 months upon the enactment of this code, rules for the registration and licensing of innovative and other trading markets or exchanges covering, but not limited to, the issuance and trading of innovative securities, securities of small, medium, growth and venture enterprises, and technology-based ventures pursuant to Section 33 of this Code. Section 38. Independent Directors. Any corporation with a class of equity securities listed for trading on an exchange or with assets in excess of 50 million pesos, P50,000,000.00, and having 200 or more holders, at least of 200, of which are holding at least 100 shares of a class of its equity securities or which has sold a class of equity securities to the public pursuant to an effective registration statement in compliance with Section 12 hereof shall have at least two independent directors, or such independent directors shall constitute at least 20% of the members of such board, whichever is the lesser. For this purpose, an independent director shall mean a person other than an officer or employee of the corporation, its parent, or subsidiaries, or any other individual having a relationship with the corporation, which would interfere with the exercise of independent judgment in carrying out the responsibilities of a director.